Morning, Counsel.
Good morning. May it please the court. Jeffrey Brown for Matthew Mogelinski, the defendant in this case. The trial court, the juvenile court, has reported 4 questions for determination by an appellate court. And on behalf of Mr. Mogelinski, I would ask you to, as the Commonwealth asks you to, interpret the word apprehended as appearing in Chapter 119, Section 72A, to mean either taken into custody or validly proceeded against and available to the court. In a couple of cases that have been cited, the court has suggested the second interpretation when someone hasn't actually been taken into custody. These facts arise, or this...
So let me ask you, would a summons suffice?
I think that it would, Your Honor. And the reason that I say that is when you look in the record here as part of the application for complaint, the police can request a warrant, they can request a summons. The clerk has to make some determination when issuing the complaint whether to issue a warrant or a summons. The clerk has some discretion there, even if the
Well,
police...
there's quite a difference, isn't there, between taking someone in hand and sending a summons out?
There most certainly is. But if taking into custody is the only way that someone can be apprehended under the statute, then in this particular case, there would be no jurisdiction, not in this case, but if someone isn't summonsed against until after they turn 18, there would be no jurisdiction. It would require that the person be arrested each and every time in order to trigger Section 72A. And I just suggested, I don't think that that was what was intended here.
Or if you took it, you'd come out in this case, you'd come out the same way if you were to interpret it to mean when the person is arraigned, whether having been taken into custody or appearing in response to a summons.
The problem with as appearing in response to a summons in this case is that after the complaint issued, the defendant turns 18, and then roughly 2 weeks later,
there would be no juvenile court jurisdiction over anything.
Right.
So if a warrant is issued rather than a summons, when is the person apprehended?
That is a good question. I think that at that point in time, because process has issued, that the person would be considered apprehended not until they're, I would say not until they're arrested in that circumstance, because they're not available to the court because of the issuance of the warrant.
And presumptively, I mean, the fact that you would say that the fact that the warrant issued as opposed to a summons, and I understand it, as I understand it, the summons is the preferred way.
Yes, in
by
juvenile court.
statute.
Yes.
So if the warrant is issued, that is one should interpret that as an implicit admission that the person isn't available to the court, or else the warrant wouldn't have issued.
I would say yes. So in this particular case, because of the dates that are involved here, the juvenile court was faced with a situation where the defendant wasn't arraigned until after he was 18. He was complained against before he was 18. The summons was issued before he was 18. And then the case proceeded under a delinquency complaint. At one point in time, the Commonwealth raised the suggestion that a Section 72A hearing was required. And at that point in time, the court requested that, I am trial counsel, requested that I file something to dismiss the complaint. I didn't think a dismissal at that point was appropriate. I filed a motion, I think it says, to confirm jurisdiction, saying that under the dicta that was previously issued by the various courts, that the defendant had been apprehended prior to his 18th birthday. The case then, the Commonwealth, upon reading my memorandum and appearing before the court, agreed with that position. The court, however, took that matter under advisement and has never ruled on that particular issue, on the delinquency complaint. And then time passed, and about 6 months later, a youthful offender indictment came out, which was issued after the defendant turned 18. And that is, in fact, the second question, which this court has subsequently answered. I think the Nanny case was pending before this court when this question was reported. And so we'd ask that you follow the Nanny decision and indicate that a youthful offender indictment cannot be had after the person has turned age 18.
So there's language at the beginning of Nanny which suggests that you can, but you think the overall case says no.
Yes, yes.
Let me ask you this. In this case, though, assuming that to be the situation, and if we accept that, your client under Nanny still faces a juvenile complaint. Well, it was said it was null pros, but a complaint could be brought for the actions, assuming you could get within the statute of limitations. Which
yes.
I don't know right now if you could, but complaint could be brought in the juvenile court, the determination made whether, under 72A, right?
Yes.
And then he could, you would, I take it, acknowledge that he can be complained about, complained against and indicted in the Superior Court for whatever offenses fit within the statute of limitations.
Yes, yes, Your Honor. I agree with that completely.
Okay. So he's, in fact, by your answers, I mean, they may be correct ones, but in a way, he's worse off than
Well-
having the youthful offender indictments.
Possibly. There's been some back and forth regarding that. I know CPCS has submitted a brief relating to this. And in this particular circumstance, if that was what were to happen, he had simply been charged after he turned 18. I think there would be no choice but to go through the 72A process. And certainly by some view, that is a worse off procedure. Practically speaking, I'm not sure if it is or isn't.
You're not suggesting here, but you're not suggesting here that because of the series of events, that option within the statute of limitations is not available to the Commonwealth.
I'm not suggesting that here. No, if this was a single act and it was complained by delinquency complaint and then indicted after the age of 18, there may be an argument that they've blown their chance because in the meantime, this defendant, has now turned 19 and the juvenile court has lost all jurisdiction on the delinquency complaint. But in this case, because the series of acts are alleged to have occurred over a very, very large span of time, I would agree that the Commonwealth may seek to proceed again by delinquency complaint. Whether there would be some type of a motion to dismiss saying that it violated the defendant's due process right, I'm sure the motion would be brought. I'm not sure that it would be allowed.
Okay, thank you.
So,
I'm now, I think, confused by your position. I had thought your position was that because he was apprehended before he turned 18, and because he had not been indicted before he turned 18, that the Commonwealth now is stuck with its delinquency complaint and can only proceed on that.
if he was under 19, that would be my position, but he's reached the age of 19, so he's aged out of the juvenile system because of the length of time that the case was pending. So at this point in time, there is no delinquency action available to the Commonwealth unless they were to seek to bring a new action, which I think is what the question was. And my answer, I think, was because there may be many offenses here that they could seek a complaint for, that could then trigger a 72A hearing.
That would be like Nanny, who was 26 at the time.
So you're saying that even though he was under 18 when apprehended, Nanny would still apply, and 72A, that procedure is still available to the Commonwealth?
It would be if he were, no, if because he's aged out, the 72A procedure is not available under the delinquency complaint. So if I'm answering your question correctly, he is not eligible for 72A hearing because he was, in my view, apprehended before he turned age 18. If the complaint were sought the day after he turned the age 18, then 72A would have been available at the beginning, which was what was initially sought, and the case would proceed in that fashion.
So if the Commonwealth were to continue in this case, under what statute or procedure would they have to proceed?
In my view, the only way the Commonwealth could continue to proceed to prosecute this defendant would be to bring a new delinquency complaint in the juvenile court, presumably for a different fact pattern or different incidents, and then the case would have to proceed pursuant to Section 72A and have a probable cause hearing and then a determination of whether the defendant should be brought to adult court.
So you can only be apprehended once. They lost their, when you say they lost their chance, he could not be reapprehended based on the old offenses alleged in a new complaint, a brand new complaint, and then a 72A hearing held.
That is my position with respect to this case. I think that I'd have to give that some thought about whether if a defendant defaulted. I think one of the cases that you've decided involved a default. Whether he defaulted whether he should benefit from the passage of time and then eliminate juvenile court jurisdiction. Those, though, aren't the facts of this particular case. But my answer to your question is yes, they only had one shot because he was apprehended prior to his 18th birthday.
So when you say that it would have to be new fact pattern, if the allegation, the complaint is that he abused, was it his daughter?
It's a stepsister.
Stepsister, that's right, sorry. He abused his stepsister between X date and Y date. What could they say now?
Well, that would probably be the basis of the defendant's motion to dismiss, that it's the same fact pattern. I guess in answer to your question, I was trying to point out that if they could establish a difference, that they could still bring a juvenile complaint. That's my position.
But I guess one problem I have with this is, let's imagine a different fact situation. Let's imagine that because of DNA, a day before a defendant turns 18, it's discovered that he's responsible for a rape of a child. Commonwealth would not have had time to indict, perhaps the grand jury is not even available, then you're saying they basically lose it because they can proceed by delinquency complaint, but they're limited to that until he turns 19. I mean, but they can't indict on that charge because...
They can't indict right off the bat. They can proceed by delinquency complaint and then seek to transfer pursuant to Section 72A and then indict if the case is transferred to adult court.
But you said only if it's on different facts, and maybe there's only a single rape here, and
Right.
and there can't be different facts.
In the case of single facts, that would be correct. However, they could just simply choose to do nothing until the day after, wait 2 days, and then they could go forward, and that would trigger Section 72A because the apprehension would be after the 18th birthday. So they wouldn't lose anything in a single fact case if they chose to wait 2 days. Under your example.
Right. And I guess the question is, why would we understand the legislature to think that makes sense? That the DA loses the ability to proceed unless he or she waits until he turns 18. I mean, that's a very strange strategic consequence with regard to a very serious crime.
I understand. I think that it is a gap in the legislation, and there's been repeated instances where relating to older defendants, there are gaps in the legislation over the years, and those cases have been cited in some of the briefs. There simply is no authority to indict as a youthful offender after someone attains the age of 18. The juvenile justice setup is simply legislatively created, and there's nothing that allows for an indictment after a defendant turns 18.
But if I want to go back to your most recent answer to my question. Why, since no jeopardy has ever attached here, correct?
Yes.
Why would it be the case that although there were, in December of, what year was it, 11? That the indictments were?
Yes, the indictments were December of 11.
So why would it be the case, if we agree with you that you can't bring those youthful offender indictments because he was over 18 when they were brought, why is the Commonwealth precluded from, and they null pros the complaints, right?
They null prost upon the arraignment of the youthful offender.
Okay, but they're null pros.
Yes.
They don't, okay. Why is the Commonwealth precluded, since jeopardy never attached, from filing a new juvenile complaint with the same allegations? As I say, you're going to be governed by the statute of limitations, I take it, but it may not apply here because of the age of the complainant, and go under 72A. In other words, why are they limited to some different fact pattern?
Well, I think that they're limited because the apprehension, if you accept my argument about apprehension, it occurred before he was 18. So the juvenile court had jurisdiction over this case up until the defendant's 19th birthday. And at this point in time, the defendant has attained the age of 19, and the case is just terminated. There's no longer any more jurisdiction.
So if they had not null pros the juvenile complaint, they might still have been allowed to proceed on that juvenile complaint under Section 72A, and sought to have him treated as an adult.
No. First of all, they only no processed, I think, 4 out of the 5.
I think they no-processed 4 at one time, but they did no-process the other one
Yeah,
at a different time.
when he reached age 19, they no processed the final one. Under your question, Justice Spina,
If they had not no processed that 5th complaint, could,
they would have been able to go forward on a delinquency complaint, but not under Section 72A.
Okay.
Because the defendant, again, had been apprehended prior to. And I realize I'm running out of time. I want to address the next question, which I think is really the 4th question, which is, if the Commonwealth cannot indict someone as a youthful offender after the age of 18, does an indictment equate to the same case or the same proceeding pursuant to Section 72, small a and small b, where it talks about the continuing jurisdiction of the juvenile court. In the case of a juvenile, the jurisdiction will continue beyond age 18 if the case is pending, and it sets forth some examples: retrial, remand, probation, and then it has language, or for any other proceeding arising out of their case. And the Commonwealth, I think, is suggesting that a youthful offender indictment is a proceeding arising out of the delinquency complaint. And I'd suggest to you that it is not, for a number of reasons. The elements are different. There's different elements relating to the youthful offender. And in this particular case, again, the time frame was different because it only relates to fact pattern between the age of 14 and 17. And there's no basis to say that it's the same case. And I don't think that's what the legislature meant when they gave the examples of remand, retrial, during probation. Well, again, it's while the case is pending. It's the same case. It's arising out of the same case. A youthful offender indictment is a completely separate proceeding that starts in the grand jury of the Superior Court and then gets transferred back to the juvenile court for proceedings. With that, if there's no other questions, I think I'm out of time. Thank you.
Good morning, Your Honors. May it please the Court, Cynthia Pepyne, Assistant District Attorney, Northwestern District for the Commonwealth. The Commonwealth would start by attempting to answer this Court's first question, which was when, for the purposes of 119, Section 72A, when should the Court find that apprehension would occur. And in an earlier case, Commonwealth versus a juvenile, the Court found when a juvenile is taken into custody, and that would make sense under what we would normally think of apprehension. In Commonwealth versus Sullivan, which was an appeals court case, the Commonwealth took the position, and the appeals court agreed for purposes of that case that when process issued, that would make sense that apprehension occurs there. And my brother, the defendant in this case, would agree and has asked this court to agree that apprehension would occur when process occurs. And I think that makes sense.
you say process, you mean when a complaint issues?
When a complaint issues.
Not when, if there's process to attend a show cause hearing for the issuance of a complaint.
I would say when the complaint issues. I think definitely not when there's an application for complaint or process for show cause hearing, because then there's been no determination of probable cause yet. So I think that
How can
Would
you
it make a
possibly
difference?
say they're apprehended upon the issuance of the complaint? I mean, that's a complete distortion of the word.
well, I think it makes sense when you look at what the purpose of the statute is it's not about catching a kid, catching a juvenile. It's what makes sense in terms of the jurisdiction of the juvenile court. We know that the legislature.
Isn't the word charged a better word than apprehended? I mean, that's what you're talking about. Once someone is charged, then they are within the jurisdiction, but apprehended.
I would agree that that terminology is awkward when you're talking about when a complaint issued. But I think it makes sense because it ultimately amounts to the same thing. When is the juvenile court coming when is the juvenile coming before the juvenile court? And it really doesn't make any difference in terms of when you're thinking about the purpose of the juvenile system and how you're going to deal with this offender, whether the kid was caught or whether there was a complaint issued and the juvenile came before the court.
Would you not make a distinction between the kind of how the juvenile is going to be brought to court? In other words, I think that the position of the defendant here is, if it's a summons, then it is the complaint and issuance of the summons. If the decision were made, complaint issues, but we don't know where this kid is, warrant, it may not be until the child actually is apprehended. I mean,
Yes,
physically
Your Honor, I would
apprehended.
agree in that
you-
case. And we do have cases, I think, Davis was a case, which was a murder case, actually, where the defendant was apprehended years later, and there are those cases as well. But in terms of, I mean, what the issue really is with the 72A transfer hearing, whether the juvenile, you have those interests in the juvenile court looking at that complaint and saying, is it consistent with the interests of justice to discharge the complaint, or is it consistent with justice for the complaint to be dismissed and for the adult court to have this case? And I think that it really doesn't matter whether there is an apprehension and the juvenile brought in handcuffs, or whether the juvenile gets there through issuance of the complaint. And I would note that the amicus and my brother here all agree, or would ask this court to find that it makes sense. You want in juvenile court, for the most part, you would like it to occur when a complaint issues, and not have to call that bright line when there's a warrant or when there's an actual arrest of the juvenile.
Or when the juvenile responds to the summons,
Yes, which would be arraignment.
which would be an
In terms
arraignment.
of arraignment, yes. And frankly,
So what happens when the juvenile doesn't respond to the summons? Has
When
there
the-
been an apprehension or no?
well, I think then the apprehension would be when there would be a warrant issued, but it's not then, because he's not apprehended when the warrant issues. It would be when inconsistent with the language in Commonwealth versus the juvenile, when the juvenile is actually brought into court, and then you would have apprehension. But again, it is, the language is a little awkward, but in terms of setting a bright line, you would have the bright line of the juvenile comes into the court, is brought before the court, or the summons issues. It's in black and white, or
So
when
here
the
you
complaint
said
issues.
Juvenile court had jurisdiction because the complaint issued and the summons issued before he turned 18.
Yes. And so then we go on to the next issue, and the Commonwealth versus Nanny was pending when this case was pending, and Your Honors decided a good piece of that by holding that youthful offender indictment after an individual has turned 18 is not appropriate, that you would, when there's been no apprehension. So, but this is not this case because we have apprehension, and the parties agree we have apprehension, so this is not Nanny. So if this were a case about all these offenses were committed when the juvenile was 14, 15, 16, 17, and he was not apprehended until he was 18, then youthful offender indictment would not be appropriate. We would have to have a complaint and then a 72A hearing. And so then what is left is an important issue, whether when you have a case here where if this court finds apprehension because there was issuance of the complaint when the juvenile was 17, and so therefore apprehension, and then there follows an indictment. And I would like to just go back to Justice Gants' hypothetical, which is what the Commonwealth has been thinking about. In many cases, you may have a situation where you could have a juvenile, a complaint issues, and the juvenile is 17, and has to be some time period for determination that there's going to be an indictment. There can be, and I know there was one case in the case where the Commonwealth proceeded strictly by indictment. There may be an investigation. Maybe the Commonwealth decides that they're working with the authorities on this, and they proceed strictly by indictment and no complaint at all. But I would say in the vast majority of cases, you're going to start a case with the complaint, and it's going to take some time before there is an indictment. In this case, there was a complaint before the juvenile turned 18, so there was apprehension before 18, and then the indictment followed. And the juvenile judge in this,
Commonwealth know the facts on which the complaints were brought.
the Commonwealth knew, well, the Commonwealth knew the facts when it brought shortly before it brought the complaints. I think there was an investigation that took place around December of 2010. The complaints were brought in May 2011, but there was an additional investigation that was going on.
But the youthful offender indictment could have been sought at that time, right? I mean, 72 suggests that they are two separate kinds of proceedings.
Well, I think I just want to point out that the juvenile judge in this case found that the youthful offender indictments supplant the juvenile complaint, and that they're based on the same conduct. There's no question that this is not about two separate types of separate sets of conduct or different incidents. And the juvenile judge found these indictments are on the same evidence as the complaints. The indictments merely supplant them, making them part of the case against the juvenile initiated appropriately when he was 17. Certainly, there's no question that the indictments took place about 6 months after the complaint. But if this court and the parties agree that there's an apprehension before age 18, the language says if there's apprehension before 18, you proceed one way. If there's apprehension after 18, you proceed another way, and that would be to have the complaint and then have the transfer hearing based on that. And this case is not, there was not apprehension after 18, the Commonwealth would submit. I would say that the juvenile judge also found that there was no prejudice to the defendant, and the defendant agreed that there was no prejudice except with regard to sentencing. And I would say that what the juvenile would really ask by the courts following the position that complaints can issue and you can find apprehension before age 18, but there can be no indictment because of the juvenile aging out and now turning 18, you can't proceed with indictment, that would really allow this juvenile to fall through the cracks in the sense of really obtaining a windfall and not allowing the Commonwealth to proceed with a transfer hearing and not allowing the Commonwealth to proceed with the youthful offender indictment. I think that goes against the language in the 1996 Act, which recognized that there are serious offenses such as this, several sexual offenses against a young person, a young child, that goes against the purpose of the Act, which was to recognize these serious offenses that juveniles can commit between the ages of 14, 17, involving threat or risk of violence, and allowing the Commonwealth to proceed in that scenario. So I think that when the Commonwealth has met the requirements of the statute, the Commonwealth should be allowed to proceed in that way. And to hold otherwise would really be allowing a juvenile to fall through the cracks when the language of the statute really doesn't permit that.
The problem is the word apprehend, though, isn't it? Apprehension. If we look for the plain meaning of the word, go to Black's dictionary, is it going to give us enough flexibility to say when a summons issues?
Well, Your Honor, I'm just looking at the other side of that. So does that mean that apprehension would have to occur, that there would have to be an arrest? And so then when in a situation where there would not necessarily be a reason to arrest a juvenile, that then you would have arrest of a juvenile. So otherwise, otherwise, I guess the juvenile is still not apprehended. So then you go back and now start anew with a case because you could have you could issue a warrant and have arrest a juvenile and start the case that way. But I don't think that makes sense within the context of the juvenile system.
Do you? So I take it you say that a new juvenile complaint could issue against the defendant, and he could be subjected to a Section 72A hearing, even though there has been a break, even though this is in effect a reapprehension. The important thing is that he was apprehended once before he was 18.
Well, but if this court finds that there was not apprehension, then and that the case can only be that that we now have a situation where a juvenile committed offenses between 14 and 17 and is now apprehended after 18, then you would have apprehension, and then I would submit that the Commonwealth could go forward with a complaint and 72A hearing. So, and I don't believe that there's anything in the statutes that says that that's not correct. As Justice Botsford stated, there's not a double jeopardy issue in this case. So,
But you're seeking to go forward on the youthful offender indictments, aren't you?
Yes.
yes, because the Commonwealth has taken the position that there has been apprehension. So if this court finds apprehension, then we are seeking to go forward on the youthful offender indictments. Absolutely, and I would submit that that's for the most part better for a juvenile. At least you have possibility of DYS commitment until 21. You have the juvenile, court.
This particular juvenile is over 21. I think I figured this out. Isn't he over 21 now?
He was born in 1993,
20.
so he's
He's 20.
20 in May this year, Your Honor.
Right.
Soon enough to be 21.
But if I understand correctly, the youthful offender indictments here cover a period of time, it's something like between 06 and 07?
Yes.
Whereas the complaints go from, I forget, 01 to
Yes.
07? Is that right?
Yes. They did go for a time when the juvenile would have been 13 or younger. And so it is over a broader time period. And that was,
Well, so if we're, I guess this goes to the point as to whether the youthful offender indictments really are different than the complaints, because
well, I would submit the judge found that they are based on the same conduct. But it is clear that the original complaints went for a time period when the juvenile was younger than 14. But it is a simple matter, I would submit, to zone down those dates of offenses through a bill of particulars and all of that. The Commonwealth has cited to the cases that say they clearly outline what types of sexual offenses you have, and you had ongoing conduct. You don't have discrete incidents so much. You have a great deal of ongoing conduct involving certain types of abuse and indecent A and B and rape of a child.
All right, thank you very much,
Your Honor.
counsel.